Welcome to another session on CL4 company law. Now, during the past few weeks of lecturing, I discussed about various elements of company law as per the common law situation in this country and especially the statutory law, which is the Companies Act. Now, today we are going to continue from where we stopped last time. That's the area of takeovers, amalgamations, mergers, acquisitions. Now, to go further on the amalgamation side, I told at the last lecture that the amalgamation procedure as laid out in the Companies Act must be followed when two companies are to be amalgamated, and the relevant statutory provisions I discussed how this amalgamation process should take place. So, next I would like to discuss that an amalgamation be affected if the amalgamation proposal is approved. Now, when the two companies are to be amalgamated, there needs to be an amalgamation proposal to amalgamate these two companies. So, the amalgamation may be effected by the amalgamation proposal is approved. That is by a special resolution of the shareholders of each amalgamating company. So, say that there are two companies to be amalgamated, A and B together. This particular amalgamation proposal should be forwarded as a special resolution, to be signed by each of the shareholders of the company A and each of the shareholders of company B, as per the provisions of section 92 of the Companies Act. Now, also, and if provisions in the amalgamation proposal would, if contained in an amendment to an amalgamating company's articles or otherwise proposed in relation to that company, require the approval of an interest group by special resolution of that interest group. Now, suppose that the amalgamation proposals were tendered as amendment to the existing articles of the amalgamated company, then they are to be signed by those who are joining in the amalgamating company, or the end result where the people who are then signing the amalgamation proposal considered as the interest group that would be amalgamating these two companies to one. For the purpose of effecting an amalgamation, the following documents shall be delivered to the registrar for registration. So, now the next step is for the amalgamation proposal that was signed or the articles that were signed of the amalgamated company are to be then tendered to the registrar for registration of the new amalgamated company. Then the approved amalgamation proposal must be accompanied with that particular documents. The set of documents to be delivered to the registrar shall consist of the approved amalgamation proposal. Then any certificates required under subsection 2 of section 241 of subsection 5 of section 242. Then a certificate signed by the board of each amalgamating company stating that the amalgamation has been approved in accordance with provisions of this Act and the articles of association of the company. Then another document is that a consent from each of the persons named in the amalgamation proposal as a director of the amalgamated company to act as a director of that company as required by section 203. So that the director who is now going to take over the directorship in the amalgamated company. Then a consent from each of the persons named in the amalgamation proposal as secretary of the amalgamated company to act as the secretary of the new amalgamated company as required by subsection 2 of section 221. So you will see that you need to deliver to the registrar of companies the full set of documents that are listed here for the amalgamation to be effected and to be approved by the registrar of companies. As per section 245 of the Companies Act, on the date shown in a certificate of amalgamation. Now, once the amalgamation documents are received, properly done, then the registrar is going to do the registration of the amalgamation in the registrar of companies. In that particular registration, then the amalgamation becomes effective if it has the same name as one of the amalgamating companies. So, the amalgamation going to be effective if it has it has the same name as of the one of the amalgamating companies. The amalgamated company shall have the name specified in the amalgamation proposal itself. So, there can't be a different name. Then the registrar shall remove all particulars relating to the amalgamating companies that were individually registered in the company's registry other than the amalgamated company itself from the register. The amalgamated company succeeds to all the property, rights, powers and privileges of each of the amalgamating companies, whereas everything then come to the amalgamating company and getting attached there. Then the amalgamated company succeeds to all the liabilities and obligations of each of the amalgamating companies also. Not only the assets but also the liabilities. Then the proceedings pending by or against an amalgamating company, especially such as legal proceedings against one company now being amalgamated, then those proceedings also come to the amalgamating company, may be considered by or against the amalgamated company. Now, in case there had been a case against company B and there is an amalgamation that happens afterwards between A and B. Now, say that the amalgamation company is called A, so that in the court with regard to the action against B, the documents are to be tendered so that it would be enabled for the case against company B are now being cited as the case against the amalgamating company. So, the case may be continued by or against the amalgamated company thereafter, because the earlier company would not exist. Now, with the amalgamation, it is going to be the new company. Or a conviction, ruling, order or judgment in favor of or against an amalgamating company, also the same, may be enforced by or against the amalgamated company. The stated capital of the amalgamated company shall be the sum certified by the auditor of the amalgamated company. So, there has to be an auditor of the amalgamated company. The amalgamated company's auditor will state what is the entire stated capital of the amalgamated company. Then any provisions of the amalgamation proposal that provide for the conversion of shares or rights of shareholders in the amalgamated companies shall have the effect according to their tenor. Now, that's about the amalgamation procedure as per the law in Sri Lanka. Now, let us look at the acquisition side. Acquisition. Now, where one company is acquired by another company. Now, this is a different scenario than a amalgamation. Amalgamation is where two companies are getting together, but acquisition is where a company is acquired by another company. There are two main types of acquisitions. Firstly, there can be a share purchase, where one company acquires the shares of another company. So, where the buyer buys the shares of the target from the shareholders. Now, it need not be the targeted company is being taken over like a fruit to by the new buyer. It is the shares that the new buyer is going to obtain of the existing company. So, suppose that there was a company C that is to be acquired by company D. So, in that case C falls inside D. So, where then the C's shares are being bought either by D, or as that is in the case as the buyer is buying the shares in the target company, it is the buying the company in its entirety, and the buyer will get all the target company's assets, liabilities, rights and obligations. So, where the company C comes within company D. And the second situation is where there is an asset purchase, either a share purchase in the first scenario, or in the second scenario the asset purchase. You buy the assets. Now, asset purchase where the buyer buys assets from the target company, then the advantage of an asset purchase is that the buyer can cherry pick the assets it wants and leave the assets and liabilities that it do not want. So, whereas in the second scenario, the company will not be bought as a fruit, as I mentioned. Part of the company's assets will come within the company D, and the rest, like this part, will remain outside. This part will be inside of C. There are many motives for any acquisition, but the overriding object should be to add value to the business. Why a company B is being purchased? Now, if you look at the economic factors, a company that is doing well will be more often be absorbed as a fruit, as I told you earlier in the first scenario. In that case, the entire share purchase is done, so that the company comes within the target company comes within the buying company. Now, the economic importance there is that when a particular company is doing well, it is always good to have the company into the buyer's company, so that the company is run as a whole. But when a company's certain sections are not doing well, but certain sections are doing very good, the buyer may target at those that are doing well. Now, if you look at a scenario such as, say, there is a company called C, and this company has several sections. Now, say sections 1, 2, 3, 4, 5. Suppose that company, these companies' sections or subsidiaries perhaps are making good profit this 5, 2, 4, then what the target would be to acquire these 3, so that the company D will acquire this one, and this one, and leave out 1 and 3. So this is the second scenario where only some parts of the company are being acquired, leaving the rest. But otherwise, the entire thing can be acquired as a whole. So there are various economic advantages and disadvantages in the move for a acquisition. One may think that acquiring certain parts of a company or certain subsidiaries of a company would be much beneficial than acquiring the whole company, the target company. Or otherwise, in the second scenario, a company may acquire another company as a whole, like a fruit, complete fruit, if they see that the target company as a whole is doing well. There are various examples, even in Sri Lanka, when certain companies were targeted and acquired. Both these scenarios did operate in various circumstances. In some cases, there have been circumstances where a particular company was acquired as a whole by another company, or certain subsidiaries of that company were acquired by this company, by this acquiring company, leaving out some other. So such part businesses then would fall as acquired companies for the acquired company, the targets for the acquired company. So there are motives for any acquisition, but the overriding object should be to add value to the business. Motives could be, these motives could be economies of scale, where combining companies, businesses can reduce duplicate departments and operations, therefore lowering the running costs of the business. Increase revenue, increase market share, whereby buying a target which is a competitor of your business, you could increase your business's revenue and to increase your business share in the market. The diversification by either geographically or into different areas in which the buyer does not already operate. Then the cross-selling, where buying a business which is complementary to the products or services your company's business. So various scenarios are there, as I have shown you. Like in this example that I took, I discussed these various scenarios. And I said that we have numerous examples in Sri Lanka where certain companies were acquired as targets, considering those different types of economic reasons. Now, as per 246 of the Act, where any person pursuant to an offer made to the holders of voting rights of a company acquires not less than 90% term of the voting rights of such company, such person may within 3 months of such acquisition give notice in the prescribed manner to all the shareholders holding the outstanding shares carrying voting rights the desire to acquire such shares, and unless the court thinks fit to order otherwise, upon an application made by any shareholder to the court within 14 days of the receipt of such notice for the acquisition of his shares, shall be entitled to acquire such shares on terms not less favorable than the terms made under the aforementioned offer. Now, this particular provision has been included in order to protect the shareholders whose shares may be out or up for grab by the acquiring company. then the acquiring company can make use of the opportunity to let the shareholders know that their shares will have a better value if sold now to the acquirer. So, by which the shareholders who are intending to sell their shares to the new acquisition company can give a good price and ensure that they get a good return. So, the law has prescribed in section 246 the best method or means of doing this. Then a copy of the notice in relation to the acquisition referred to earlier shall be forwarded to the company, that the intention that these not less than 90% of the shares are to be now acquired by an acquiring company, so that then the rest of the shareholders become aware that their shares will have a good market to sell to the new acquiring company, the shares of which are to be so acquired. Where any person has given notice on the expiration of 1 month from the date on which such notice was given, such person shall forward the due consideration to the company. That means that where any person has given notice of a share sale on the expiration of 1 month from the date on which such notice was given, or the acquisition notice was given, then the shareholders can offer their share. Such person forward the due consideration to the company. The acquiring company can give the consideration, the value of the consideration for the shares, the amount for which that acquirer is going to acquire the shares. The shares of which are to be so acquired, and the company secretary of such company shall register such acquirer as the holder of such number of shares. So that then the rest of the shareholders who are remaining with the shares of that particular company, the targeted company, then can have a better idea that what sort of a market their shares would have. Any consideration received by the company shall be held. So, when the acquiring company, the acquirer, makes out a particular figure for which the company shares are now purchased, then that particular consideration received by the company, the target company, shall be held by that target company on trust for the person or persons entitled to the shares in respect of which the sum or other consideration was received. So, when that investment go to the targeted company, that investment becomes a trust for the shares of the investor acquirer company shareholders have invested upon. The company secretary of such company shall forward such consideration to all shareholders without any undue delay. Thereafter, the share transfers need to be done perfectly by the company secretary. Where after reasonable inquiry is made at such intervals and the publication of notices in all 3 languages in daily newspapers, whenever there is an acquisition to take place, so the due notices have to be dispatched, and newspaper advertisements as to the buying out of such shares are to be publicized, so that the general public knows that this company shares are now being acquired by a new acquirer. So, the person entitled to pay entitled to any consideration cannot be found, and 6 years have elapsed since the consideration has been received by the company is wound up. The consideration together with any interest, dividend and other benefit that acquired from it shall be paid by the company to the public trustee. Now, once it is published that this particular company shares are now being bought by the new acquirer, and if the rest of the shareholders who hold shares do not come during the particular period and to the expiration of 6 years, then rest of the shares that have not been claimed by those who hold the shares, the value that has not been claimed, that particular value will go to the public trustee. Then the shareholders coming afterwards will have to sort the matter with the public trustee. Anyway, that money will go to the public trustee for those shareholders who have not yet claimed within the prescribed time period that I mentioned. As per section 256, notwithstanding the provisions of this act or the provisions contained in the articles of a company, the court may, on the application of a company, an administrator appointed under part 13 or with the leave of the court, any shareholder or creditor of a company, order that an arrangement or amalgamation or compromise shall be binding of the company and on such other persons or class of persons as the court may specify. Any such order may be made on such terms and conditions as the court thinks fit. So this is a special provision that has been given in such a kind of acquisition where those who are entitled for the receiving of the particular consideration against their shareholding, then to obtain the particular amounts as per this provision. Now, if you look at some English cases with regard to this area, now in Sri Lanka we do not have that much of a developed case law system with regard, developed case law with regard to the amalgamations, acquisitions and mergers and so forth. What are the problems that are being faced at times of such amalgamations or takeovers or acquisitions? Now, there are some interesting cases that happen in UK and in other countries where I refer to the case of Ray, Alabama, New Orleans, Texas and Pacific Junction Railway Company. This is where a scheme of arrangement at least be so far as fair and reasonable. The court held that when there is a particular amalgamation, merger or acquisition or whatever, a scheme of arrangement at least be so fair and reasonable for the amount that is being given as for the takeover, as that an intelligent and honest man who is member of that class to whom the scheme is put and acting alone in respect of interest as such a member might approve it. So, whereas the court requires that whenever a proposal is made, the proposal is made in clear language, but an intelligent and honest man can understand and how it could be fair and reasonable on the part of the shareholders. It enables a compromise to be forced upon the outside creditors by a majority of the body or upon a class of the outside creditors by a majority of that class. It would be most unjust to bind creditors or classes of creditors by the decision of 3/4 in value of those who attend a particular meeting unless you have secured that the meeting shall adequately represent the entire body. So, this is pretty much needed as held in this particular case. And in the case of Ray Hellenic and General Trust Limited, the court rejected the scheme of offering for the buyout because the 53% shareholder ought to have been placed into a separate class for voting purposes since it was a wholly owned subsidiary of the acquirer. Now, this case is a different scenario where the subsidiary belonged to the acquirer itself and the acquirer now acquiring the subsidiary as a part of the main company, not as a subsidiary to remain as a subsidiary anymore, but to acquire it to the main company. Then the court here rejected a scheme because the 53% shareholders ought to have been placed into a separate class for voting that gave them some disadvantage rights purposes since it was a wholly owned subsidiary of the acquirer. In the Ray Challenge Bank Limited case, The court referred to the general principle that a court may decline to approve a scheme if it is not satisfied that the scheme is at least so far fair and reasonable as that an intelligent and honest man who is a member of that class and acting alone in respect of his interest as such member might approve it. In this Australian case of Kumarina Resources Limited, this is a very important case that was decided in Australia. Now, Kumarina Resources proposed a scheme of arrangement with its shareholders pursuant to which shareholders would receive 1 Zeta Resources Limited share for every 4 Kumarina shares plus 1 Zeta option for every 5 Zeta shares issued. So, this is a quite complicated thing because they offer the Kumarina shares for another company shares, multiple number of shares that are to be given in place of acquiring certain number of shares in this Kumarina Resources. The resolution approved the scheme was passed by 79.0% of the shareholders who voted at the scheme meeting. 2 dissenting shareholders objected to approval of the scheme and asserted that 3 shareholders who between them held just under 40% of all shares on issue at the time of the scheme meeting, all of which they voted in favor of the scheme, should be treated as being in a separate class or otherwise should have their votes disregarded by the court. The court held that it must find that the objective, intelligent and honest member would consider the scheme fair and reasonable, having regard solely to that member's interest as such a member, and not any other interest. Where the success of a vote to depend entirely on votes of members whose approval of the scheme was equated by their extraneous commercial interests, there may be cause for concern about the overall fairness of the scheme. So, now you see how the court looked at the proposed arrangement. This is where the court would intervene in a case of an amalgamation or buyout or takeover or whatever it may be of a company. The court will look at the fair and reasonableness of how this acquisition is going to take place, how fair and reasonable this buyout is going to take place. So, the court can intervene in such circumstance to pronounce justice to those who are really affected, especially the shareholders who are being either affected unduly or being treated differently in such a process of a buyout or sellout. Now, with that, we finish the area of amalgamation, takeovers, acquisitions and mergers section. Now we are almost coming to the last part of this lecture series, which is on the winding up procedures and the law relating to dissolution of companies. Now, we had been discussing right throughout this lecture series how companies are incorporated, how companies have to flow or how companies have to carry out its business activities and the existence, and now we are coming how to end a company's existence as a legal entity. So, for that we discuss the area of company dissolution, liquidation and winding up for today and the last day, which is the next day of lectures that would bring this company law, corporate law lecture series to an end this time. So, company dissolution is the process by which the company comes to an end. Now, before a company comes to an end, there are certain legal procedures that you got to follow. Those are laid down in our Companies Act as well, how a company is to be dissolved. Now, if you compare the law between Sri Lanka and England, now in UK there are various acts under which companies are to be wound up and dissolved. But in Sri Lanka, it is one particular act, which is the Companies Act number 7 of 2007, that lay out the procedure in which how companies should be closed down. Now, there are various types of closing that I would be addressing in the time to come in these presentations. But first of all, let us see what is a dissolution of a company. Now, dissolution is the final point. That is where a company is dissolved. So, from the time the company is dissolved, there is no existence for the company. The legal entity, the company, comes to an end, comes to a death. So, therefore, dissolution of a corporation is the termination of a company or the corporation. Dissolution of a corporation is carried out by filing documents to withdraw corporation as a business entity. Now, likewise, we commence the operation or incepted a company by way of documents that we discussed, gave to the registrar. Now, even the dissolution has to be done in the proper documented manner. So, the documents are the most important things that to be deposited with the registrar of companies, so that the registrar of companies can really put an end to a company. Dissolution can either be started voluntarily, that means where the shareholders would voluntarily prefer to bring the company to an end, or that by resolution of the shareholders, when the shareholders feel either the company is unable to pay its debt, or that the company is not doing good in its business, or that the company creditors are more than what the company really hold as assets. So, in different circumstances, the shareholders might propose to have a resolution to dissolve a company, or as I told you, the involuntary way, that is where we call a forced closure, that is either by the creditors or by the court, by the competent court, where it comes to a forced closure, involuntary way of closing down a company, dissolving a company, for not settling the creditors, or by court for certain determined causes, as I said, the forced type of a closure. To dissolve a company, also known as dissolution or striking off. Now, dissolution is where you dissolve a company. You put the company to an end in a way that you kind of destroy. Or we call it also striking off because, as I told you, likewise the companies are created by documents. Companies are also dissolved by documents. So, whereas the documents are tendered to the registrar, then the registrar takes steps to strike off the name of the company from the register of company. It is not easy though. There is a procedure to be followed in different ways, whether it is voluntary, whether it is by resolution, whether it is by court, whether it is by creditors. There have to be a certain procedure that is to be followed in order to close down or dissolve a company. So, striking off is where the company is struck off from the company register. Is a way in which a company can remove its name from the official register, and once the name is removed, the company no longer legally exists. So, there is a inexistence of the company. The company does not exist anymore. Now, interestingly, when a company comes to such an end and it is when it is struck off from the company register, there is no existence for the name of the company. So, after the name is gone, like we go to the beginning, when another person wants to have that company name, is that possible? Yes, it is possible, because that new name does not exist as an existing company in the company register. So, that the new name, which may be similar, could still be taken by the new prospective company to be incorporated. So, company name would be struck off, then that would be the end of the existing of that particular company. As per section 316 of the Companies Act number 7 of 2007, where the affairs of a company have been completely wound up, the court shall, where the liquidator makes an application in that behalf, make an order that the company be dissolved from the date of such order, and the company shall be dissolved accordingly. Now, you see, the dissolution, as I told you, is the final point. So, before comes into the dissolution, there is a procedure to be followed, such as the winding up of the company. So, the winding up process has to take place, and thereafter only the dissolution will come into effect. A copy of the order made under the provisions to wind up the company and to dissolve from the court within 15 days should be deposited within 15 days from the date of such order, so that the company winding up dissolution order should be made 15 days from the date of the order of the court that pronounced that the company is dissolved. So, once you obtain the order, within 15 days you have to deposit with the registrar. Be forwarded by the liquidator to the registrar, who shall make in his books a minute of the dissolution of the company. I will later on revisit these terms of liquidator and other, but as you see, under this particular section it says how a company comes to the final dissolution. Now, before that I told you that certain procedures have to take place. Therefore, the dissolution of a company commences with number 1, the winding up process. So, winding up process is the number 1. Now, when winding up, there are several matters to be done, several things to be done. As per section 206, the winding up of a company, so where you wind up a company, may be done either by the court, number 1. The court can wind up a company. Then it can be done voluntarily by the members of the company, such as the shareholders. But in a voluntary wind up, what is important is that the company will have no liabilities to the outside, which means that the company's balance sheets come to a zero. Whatever the profits that the company may have can be distributed among the shareholders as per their shareholding to the percentage, and finish off and bring the accounts to zero. If in case that there is any type of liability that the company cannot meet, then you cannot go to a voluntary wind up. So, voluntary wind up, or the third one, is subject to the supervisions of the court also. The company can be wound up. So, when a company needs to be wound up, or when a company is put to a winding up process, firstly you need to start the winding up process. When a company is expected to be dissolved, you have to start the winding up process. So this is where the commencement occur. Now let us look at the first area, winding up by court. This winding up by court is completely a legal process. That is where the court take all the necessary steps in doing the winding up. But however, how can one invite the court to wind up a company? I mean, generally a court will not, as you know, interfere in or intervene in company affairs. The court has to be moved by someone to do this winding up. Whereas the court then comes into the picture, the court interferes or intervenes in this process and carries out the necessary legal measures in order to do this winding up. So first of all, it is important that the court is moved to wind up the company. So how to move the court? One has to bring an application to the court by way of a petition to petition the court to wind up a company. So you need to petition the court to wind up the company. As per section 270, a company may be wound up by the court. On what grounds? On what grounds a company may be wound up? Now when a petition comes to the court should be satisfied that the petition declares or bears out either of the following circumstances to wind up the company as it is being requested or prayed for in the particular petition. Now, what are the grounds on which a court can wind up a company? Firstly, the company has by special resolution resolved that the company be wound up by the court. Number one, that there should be a special resolution by the company. Number one is special resolution by the company be wound up. The company has by special resolution resolved that the company be wound up by the court. So that gives, the special resolution gives the power for the court to wind up this company. Say the company is A, so the company to be wound up, there is a special resolution passed by the company allowing the court to wind up this company. So either you have this number one requirement met in the particular petition, or secondly, where the company does not commence its business within a year from its incorporation or suspends its business for 1 year. The second point by which a company can be wound up by court is where the company's operations, business operation, either does not commence within the first year of its incorporation. Say that the company was incorporated on 1/1/2020 and by 1/1/2021, 1 year has lapsed, there has been no operation. No operations of the company for 1 year. We'll say 1 year or more. Or else that at a certain juncture after its incorporation, the company has come into a standstill, that its business operations are not happening for a continuously 1 year period. Which means that, say the company was incorporated on 1/1/2020, but by 1/5/2020, this was, say this was in operation, but between this time and another 1 year's time, say till 1/5/2021, the company did not exist, dead. So then in that case, this could be a reason for the company to be wound up. So no operation for 1 year at least after being incorporated, or it has been suspended, no operations. In the case it's suspended, its operations are being suspended, operations suspended for 1 year at least. So if there is a ground like this, then that will give power for the court to allow the winding up process to commence with the final objective of being dissolved. Thirdly, if the number of members fail below the minimum number required under section 2 of subsection 2 of section 4 of this act, that means that third situation is where the company shareholding. You know that in Sri Lanka, for a company, private company, you need at least 2 shareholders, right? At least 2 shareholders. So when that shareholding is not met, I guess, one shareholder, but in case of a public company, you can have 1 shareholder. Private company, you need to have the sufficient number of shareholding to be, and at least 1 director company. So if that particular foremost requirement is not met, then in that case, then the company for that particular reason can be wound up by the court, right? Failing to meet minimum members required by subsection 2 of section 4 of this act. Or the fourth one is that the company does not have directors, no directors. Without directors, you cannot run a company. But with 1 director, you can, under our law. But when there are no directors, you know that the company cannot run then. The company needs director. Director is the agent. Director is the person who is in charge of the management and administration of the company. So there has to be a director. So when there is no director, the company cannot exist. So if such a situation occurs, this will provide the fourth ground on which a company may be dissolved, a wound up procedure can commence by the court. Then, the next one is that the company is unable to pay its debts. As I told you, that the fifth situation is unable to pay debt, because a company is not expected to operate completely with debts that cannot be paid by the company. Because what happens there is that then the artificial person, the company, becomes so unsecure that it cannot meet its liabilities. The artificial person will become a victim finally, that it may not be able to pay out the debts. So when a company is unable to pay its debt, that will provide a ground for the court to start the winding up process with the sole object, with the ultimate objective of dissolving the company. Then the next one, or if the court is of the opinion that it is just and equitable that the company should be wound up. So the sixth situation is opinion of the court. Opinion of the court, where the court is opinion that the company cannot exist fair and just and equitably. Just and equitably. The company cannot exist just and equitably, so that winding up of this company is what it should be for the benefit of this artificial person, the company. So you see that when a company to be wound up by way of a court, the petitioner who petitions the court must prove or bring out a ground that can be proved as existing one of these six. One of these six grounds need to be present, need to be shown by the petitioner who is now seeking for a winding up and final dissolution of a company. So no other matter for which a company can be wound up or dissolved by court. So for a court to dissolve, the petitioner must prove one of the six in existence. Now, first one, of course, you can understand very simply. When there is a resolution being passed by majority vote, if not a unanimous vote, then the company requires it to be dissolved. Second one, the statutory requirements have not been met. Third one, again statutory requirements have not been met. Fourthly, statutory requirements have not been met. Fifth, unable to pay debts, which is more of a economic reason. That, as I told you, that the law does not expect an artificial person such as a company to unduly become a victim of an economic scenario. That it cannot meet the debt that it owes to creditors outside or inside, whatever, it cannot meet the creditors' demands, because the creditors have given debt and the company is now unable to meet that debt. Of course, the sixth one is opinion of the court, where the court see that it is on fair, on just and equitable grounds that it is better for the company to be wound up. Otherwise, the company as an artificial person may suffer enormously, which the law would not recognize such an artificial person to suffer. Now, what is important here is that the fifth one that I have taken, where a company cannot meet its debt or unable to pay its debt. Now, what it means by a company shall be deemed to be or company, what it amounts to, the meaning that a company is unable to pay its debt is where, as mentioned in the Companies Act, where a creditor by assignment or otherwise to whom the company is indebted in a sum exceeding 50,000 rupees then due has served on the company by leaving it at the register office of the company a demand under his hand requiring the company to pay the sum so due, and the company has for 3 weeks for the date, so leaving neglected to pay the sum or secured or compound for it to the reasonable satisfaction of the creditor. Now, what does it mean? When a company has taken a loan from a creditor and the loan is now amounting to 50,000, and the company, the creditor has served a demand for the attainment of that 50,000 by himself or herself, but the company does not have sufficient assets to pay out that debt, then the company is given 3 weeks to settle that amount, failing which the company will have to go for a winding up. Now, who will commence the proceedings here? Either the proceedings can be commenced by shareholder, where the company has received a demand from the creditor. The shareholder of the company can say that the company is unable to pay this debt of 50,000, and therefore the shareholder petition to the court that the company is unable to pay debt as demanded. Or else the creditor, having satisfied that the company is unable to pay the debt of 50,000 that the creditor has demanded, then in such a scenario the creditor himself can petition the court, that stating that the company is unable to pay his debt amounting to 50,000 and has given 3 weeks to settle, but the company has failed, so then to make the application. That also refers to a situation of an unable to pay its debt. Secondly, execution or other process issued on a judgment, decree or order of any court in favor of a creditor of the company's return unsatisfied in the whole or in part, or where there is a court order that has been given in favor of a creditor of a company to recover certain money, and that certain money cannot be paid by the company, then in that case the creditor or the shareholder can petition the court to wind up this company on the ground that the company is unable to pay the debts. C, where it is proved to the satisfaction of the court that the company is unable to pay its debts, and in determining whether the company is unable to pay its debts, the court shall take into account the contingent and prospective liabilities of the company. The third situation is where either a shareholder or a creditor show to the court that the company is not going to make business or profit, income to meet its debts, and therefore it is better for the company to run into a closure, and for that reason they can petition the court seeking an order to wind up and dissolve on the ground that it is unable to pay its debts. So, in all these three situations that fall within the term unable to pay its debts, the petitioners can petition to the court seeking a winding up of the company with the ultimate objective of dissolving that company. An application to the court for the winding up of a company shall be by petition. So, it has to be a petition. Whenever there is a petition, you need to support it with an affidavit. That is the legal process. That is the legal process. Now, petition is where the court is being petitioned as to the relevant circumstance, and such petition has to be supported by way of an affidavit where the petitioner, the person who is petitioning the court, must give kind of written evidence, written testimonial that what the contents of the petition are true and to the best of the knowledge of the petitioner, correct, and give a testimonial like kind of way of evidence that the petitioner himself or herself is admitting these facts what have been mentioned in the petition. So, the petition has to be coupled or accompanied with a affidavit in that circumstance. So, the petition should be presented subject to the provisions of these sections in the Act, either by the company or by creditor or creditors, including any contingent or prospective creditor or creditors. Now, what is interesting here, who can be parties to a petition such as this that sought the company dissolution by way of a court, where binding up by court. Who are the petitioners? Who are the petitioners? Petitioners who can be parties in petitioning the court. Number one, the company. The company by its own name can, because it's an artificial person, it has the legal title as a juridical person, legal person who can stand by itself in front of the law, right. So, therefore, the company can become the petitioner, or else the creditors or creditor of the company who have given debt to the company and the debt become unable to pay back by the company. In situation, either the company or by any creditor or creditors, including any contingent or prospective creditor or creditors. Then contributory or contributories. Thirdly, contributory or contributories. Who are these contributories? I will show later the real meaning. This could include the shareholders of the company, but here we do not call them shareholders, because the company is now going into a winding up. When the winding up procedure starts, there can't be shareholders. The company's existence is no more than, it is going into a closure, to an ending, to an end. So, therefore, we call the shareholders here as contributory or contributories. In that case, the contributories, the name suggests that they have to contribute. What do they have to contribute? They have to contribute the share value. What they have initially either paid or agreed to pay at the time of closure. Now, I am taking your knowledge back to the time that we talked about the company shareholding, where I said that there are different types of shareholders. There are shareholders who pay their share value at the beginning or during the existence of the company, or they wait until their share is being called for to contribute at a time of a dissolution. So, they are all contributories, or by all or any of these parties, jointly or severally. Either they can do it separately, or even they can join together, this one and this one, or this one and this one. Either they do it individually or jointly. Here, a contributory means, as I explained to you earlier, every shareholder of the company and every other person liable to contribute to the assets of a company, such as the shareholders that have taken shares on call, or as a redeemable shareholder, or the shareholders who have not settled their money until then, or the existing shareholders who have settled ordinary shares, contributed to the assets of the company in the event of its being wound up. So now, when the petition is made and the court is being petitioned to commence the winding up, the court will look at the petition. The petition will consist of the entire scenario made in several number of pages that the case is mentioned, this is what has happened, this is now where the company is, now the company has come into this position, so therefore a winding up and further dissolution is required. So if when the documents are tendered to court and then the court is satisfied that the proceedings have to now commence, now then the court will start the winding up procedure and decide, by going through the petition, this company needs to be wound up. Then the winding up procedure commences and will go on until finally the court orders that the company is now dissolved. So from the time the company winding up is petition, we say petition, and then going into dissolution, the winding up process take place. Winding up process take place from this point to this point. The winding up process take place from this point to this point. So you see that winding up is a process, and during this process there are so many steps to be taken, and these are the steps we will be learning. Now, what are the steps to be taken until the final dissolution is going to be done by the court in this way of a winding up by court? Now here, a contributory shall not be entitled to present a winding up petition. Now I told you that the contributory is generally entitled to make a petition, as I told you, the four parties, right, rather the three parties, right, the company, creditors, contributors, right. But out of which the contributors are not entitled to present a winding up petition unless the number of members fall below the minimum number required under subsection 2 of section 4 of this Act. That means that the minimum requirement of shareholding is met as per the Act, or the shares in respect of which he is a contributory or some of them either were originally allotted to him or have been held by him and registered in his name for at least 6 months during the 18 months immediately preceding the date of commencement of the winding up, or have developed on him through the death of former holder. That means that the first scenario you understand, where a contributory should be somebody who has been there as fulfilling subsection 2 of section 4. The minimum number had been there. If there was no minimum number, then the remaining shareholder cannot come to court for a winding up, because in that case then it is then a creditor who will have to petition the court, or the company as a person can come to court when the minimum number is not met. Second situation is where a contributory who is coming as a petitioner must fulfill the fact that he was a shareholder at least during the last 6 months of the preceding 18 months of the company. That means, for example, say the company is to be wound up or petition for winding up today. Now today's date will put us 20th September 9 of 2020. Now from today you take 18 months backwards. 18 months in the sense that then 8, 7, 6, 5, 4, 3, 2, 1, that is the January 2020. So we have 8 months, then another 10 months in the sense December, November, October, September, August, July, June, May, April, March. That means March 20th will take 2019, right? This is 18 months. 18 months. So within this 18 months period, a contributory who is going to now petition for winding up must have been there for 6 months period, either here 6 months or here 6 months or at the end 6 months, whatever, doesn't matter. Within this 18-month period, the particular contributory in the petition who petitioned must have been there for at least 6 months, period as a shareholder. Then only that particular shareholder can be considered a competent contributory to petition for winding up. Or else, either he had been holding as a shareholder, or he has been holding the shares as for a deceased shareholder, that this particular shareholder was bequeathed with the shares as per a trust or by last will or by intestate of that particular original shareholder. So either the shareholder contributory was there for 6 months during the last 18 months as a shareholder himself, or by virtue of having shares of a deceased person, former holder. The court shall not give a hearing to a winding up petition presented by a contingent or prospective creditor until such security for costs has been given as the court thinks reasonable, and until a prima facie case for winding up has been established to the satisfaction of the court. Now, what it says here is that when a winding up petition is petitioned by a contingent or prospective creditor, when a creditor petitions for a winding up of a company, then that creditor must show that there is fair ground, there is fair ground that this company should go for a dissolution, and it is not on unfair grounds, and it should not be also on mala fide or on some bad faith, but have very serious grounds for which that the creditor is petitioning, and that he should be able to show a prima facie case on the face of it that this company is heading for a bankruptcy. In that case, then the creditor will have the chance to come forward and petition for a winding up, but also he must give a security of undertaking for the costs that the company will have to bear in these proceedings to come and appear through a lawyer and so forth, so that the company has to bear the money to appear before the court. That particular cost should be borne by the creditor, because the Lord will not want again to put the artificial person into a difficulty. Always the law looks at protecting the artificial person, the company. So therefore the creditor of such nature must come up with such a undertaking as to the cost. The registrar may present a winding up petition in the case of a company referred to in subsection 3 of the section. Now, apart from those three persons, the company, creditor or contributory, the registrar of companies can also petition the court for a winding up of a certain company. Those are where the liquidator been appointed upon the inspector's report, where the registrar has put a inspector to look at the company's existence and how the company is doing, and there is a report being taken, and then the registrar appoints a liquidator to see whether the company can really exist, and if the registrar is reported that the company's affairs are not that solvent and it may go into a bankruptcy, then in that case, without standing on the company or the creditor or a contributory to come to a case, the registrar himself can petition the court to wind up this company with the ultimate objective of dissolving the company under subsection 3 of section 177. The court shall not make a winding up order or on the petition unless it is satisfied that the voluntary winding up subject to the supervision cannot be continued with due regard to the interest of the creditors or contributories once the official receiver attached to the court as well as by other person entitled to report so. Now, once the court receives the petition for winding up, what the court will do next is appoint a receiver. Receiver appointed by the court. There are competent people, including attorneys at law as well as the accountants, who may be competent people to look at how a company is being conducted. So the the receiver will be appointed by the court, that the receiver will thereafter inform the court of the existence of the company, whether the company can exist without running into bankruptcy. So then the receiver will report back to the court. Based on the receiver's report, the court will take the decision whether to continue with the winding up or whether to stop the winding up process and let the company to function. So when the court is satisfied by the receiver's report, then the company, having due regard to the contributories and the creditors and so forth, then will proceed with the taking of the winding up procedure. On hearing a winding up petition, the court may dismiss it or adjourn the hearing conditionally on conditionality, or make an interim order or other order that it thinks fit, but the court shall not refuse to make a winding up order on the ground that the assets of the company have been mortgaged to an amount equal or excess the assets, or that company has no assets. Now, when the court attends to the winding up proceedings, in between the court will look at how the company behaves and to see what sort of affairs that the company been going through. So the company, the court can make interim orders or final orders. Final orders in the sense that if the court is satisfied that the company can very well exist, even at a in between juncture, the petition will be thrown away by the court, refuse, so that the company can function. Or it may make interim orders for the company affairs, like for example, if there are certain receivables are to be received, then the court can make orders to the liquidator or the receiver, so appointed, to attend to those things, hold the meetings, try to bring the accounts to a finalization, right? And those kinds of things can be conducted, and the court is doing that for the sole interest of the company. And then a court can make interim orders, and when making interim orders and orders of such nature, the court is not obviously tend to look at what sort of assets are being mortgaged of the company, what sort of like assets are in excess, or there are no assets, or all kinds of things. It's not for the attention of the court. It's not of concern for the court. The court is more concerned of the reports that are given by the liquidator, by the receiver, whether this company can go ahead, move ahead, or whether this company has to run into a dissolution. As per section 273(2), where a winding up petition is presented by shareholders of the company as contributories on the ground that it is just and equitable that the company should be wound up, the court shall be of the opinion that the petitioners are entitled to relief either by winding up of the company or by some other means, and in the absence of any other remedy, it would be just and equitable that the company should be wound up, make a winding up order unless it is of the opinion that some other remedy is available to the petitioners and that they are acting unreasonably in seeking to have the company wound up instead of pursuing that other remedy. Now, there can be situations where a certain company is expected to be wound up by the contributories just for the mere sake of the contributories. Now, the court will not allow such a thing. The court will not allow such a thing to happen. The court will not allow the contributories or the shareholders to take the matter granted. The court will always look at what sort of a benefit or detriment the company will experience, so that the court will be careful in determining whether to let the winding up process go on or whether to suspend it and adjourn it so that the company can run further. So, if the court is satisfied in the case where the petition is being moved by the contributory or contributories, it is for the benefit of the company that the company should be wound up, then in that case the court will continue with the winding up process. In a winding up by court, any disposition of the property of the company including things in action and any transfer of shares or alteration in the status of the members of the company made after the commencement of the winding up shall, unless the court otherwise order, be void. Now, when the winding up process commences, any action thereafter by the company administration, whether to do business, whether doing business, or a transaction, or a signing of an agreement, whatever that the administration of the company is doing would be void. Because when a winding up is being heard by a court after being petitioned, all the matters come within the purview of the court. It is the court that will look into the matter. Court by way of appointing receivers or administrators or liquidators or whoever. The court will look into those affairs. So, the administration of the company that existed prior to the commencement of the winding up process come to a halt. They have no authority to go ahead. So, if they go ahead with any kind of transaction whatsoever, such transaction would be void. There will be no effect, no legal bearing. For example, if a third party comes into an agreement with the existed administration, the third party will be in danger. The third party will be prejudiced because he is not going to get any benefit out of it, because the matters have now come within the purview of the court. The administration that existed have nothing to do with it. On the making of a winding up order, a copy of the order shall forthwith be forwarded by the company or otherwise as may be prescribed to the registrar, who shall make a minute thereof in his books relating to the company. Now, once the winding up proceedings commence, that the court gives an order that now this company is to be wound up, okay, not dissolution, wound up, then that particular order needs to be registered with the registrar. So that then the registrar sees that this company has come to an end, and thereafter this company is going into a dissolution, right? So that no operations can thereafter affect with regard to this company. And even the annual payments that the company has to pay and those kinds of things also come to an end there. That the registrar cannot demand a company that is in winding up process to still pay the annual fees or ask for annual reports, returns and so forth. It all comes to an end because there is a winding up ordered by the court. So, the registrar needs to deposit that order with him. When a winding up order has been made or provisional liquidation has been appointed, no action of proceedings shall be proceeded with or commenced against the company except by leave of the court. Now, suppose that when a winding up has been commenced and a liquidator has been appointed, that is to look into the matters of the company and finalize all the accounts and transactions, at that moment, whoever who is going to file a case, legal action against the company, or whoever who has already filed a legal action, must then bring that matter to the attention of the court. That either a case is to be filed against this company, or there is an existing case that has not been disclosed in the winding up process. Whatever, the court needs to be informed of. And subject to such terms and conditions, the court may impose. The court might say in such a situation that such proceedings either be suspended or adjourned, or they be brought into the main case or be informed to the liquidator, so that the liquidator takes the necessary steps with regard to that case. Maybe that the liquidator reports to the other court on what is happening in this court with regard to the winding up, all these things. The court will direct. However, it shall not apply to an execution process or attachment against any property by or for the benefit of a creditor who is entitled to charge in respect of that property. Now, in case, while the winding up proceedings have commenced, there is an order that is made against this company, enabling a creditor to obtain certain property, immovable or movable, whatever, then such order held in favor of the creditor must be brought here to the winding up proceedings, and then will be taken as a charge of that. And unlike in the former circumstance that I mentioned, that all such things need to be informed and the court needs to have the cognizance of continuing or whatever the actions. Here the court will take notice of such and will be put. So, if the particular order is to claim certain part of the property of the company, then that becomes a liability for the company. That becomes a liability for the company, because that will not, that part of the property will not proceed further in the winding up process, in dissolution or in distribution of that particular assets among the shareholders or among the liabilities. That particular portion of the property will be taken away, because that has to satisfy the order given in respect of that particular case, that is under liability for a certain creditor or on a charge. An order for winding up a company shall operate in favor of all creditors and of all the contributories of the company, as if made on the joint petition of the credit or contributory. Now, suppose that application was made, application for winding up and dissolution was made by the shareholder, contributories and the creditors together. The order will be in favor of those who have petitioned the court. So, whatever the remaining things that are being decided by the court to be distributed among the creditors and the contributories will be done according to the order. If in the case of the winding up of any company by court, it appears to the court desirable with a view to securing a more convenient and economical conduct of such winding up, that some officer other than the person who would, by virtue of the provisions of section 281, be the official receiver, should be the official receiver for the purposes of that winding up. The court may appoint that other officer to act as official receiver in that winding up, and the person so appointed shall be deemed to be the official receiver in that winding up for all purposes of the act. So, this is where for procedural matters, where the persons are appointed as receivers and official receivers appointed by the court, these procedural provisions will apply. So, if the court is desirable with a view to securing more convenient and economical conduct of such winding up, that some officer of the court other than the person who would, by virtue of the provisions of section 281, who are these official receivers, which I have mentioned in the next para, that under section 281, official receiver, so far as it relates to the winding up of a company by court, means the official receiver, if any, attached to the court for insolvency purposes, or if there is no such official receiver so attached, to the court such person as the minister may appoint as official receiver to the court. So, the court will always try to obtain the services of the official receiver as much as it can, but in other circumstances the court may appoint that other officer to act as official receiver in place of an official receiver in the winding up, and whoever so appointed shall be deemed to be the official receiver in this matter, in the winding up for all purposes of this act. Where the court has made a winding up order or appointed a provisional liquidator, where the court has made a winding up order or appointed a provisional liquidator to look into the matters and find out what are the financial implications and to finalize the accounts, unless the court thinks fit to order otherwise, or so orders be made out and submitted to the official receiver a statement in the prescribed form of the affairs of the company, verified by affidavit and showing particulars of its assets, debt and liabilities, the names, residences and occupations of its creditors, the securities held by them respectively, the dates when the securities were respectively given, and such further or other information as may be prescribed or as the official receiver may require. So, the official receiver and the liquidator has a huge role to play in securing all the related information that are necessary to be submitted to court, enabling the court to take the winding up process further in a more formal and proper manner. In case where a winding up order is made, the official receiver shall, as soon as practicable after the receipt of the statement to be submitted, or in any case where the court orders that no such statement shall be submitted, as soon as practicable after the date of the order, submit a preliminary report to the court. So, once the official receiver is appointed, then it is the official receiver's duty to look into all the matters as I mentioned forthwith and report to the court, detailing out the things and materials that are relevant to the company, and as a kind of a preliminary report. This is not the final report. First and foremostly, the official receiver is to submit a preliminary report. Now, in the preliminary report, what does he has to mention? He has to mention as to the number and types of shares issued in the company, the stated capital as per the articles of association, and the estimated amount of assets and liabilities, where the company has failed, as to the causes of the failure. It is like an opinion how the company has failed in its business, whether in his opinion further inquiry is desirable as to any matter relating to the promotion, formation or failure of the company or the conduct of the business thereof. That is also to see whether the directors are in fact personally liable, kind of lifting of the veil, to see whether the directors have taken some damaging decisions, so that to put that liability on the directors' private means. As per section 285, for the purpose of conducting the proceedings in winding up a company and performing such duties in reference thereto as the court may impose, the court may appoint a liquidator or liquidators. Now comes the court to appoint a liquidator. Liquidator is a person who is going to see what are the assets of the company, what are the liabilities of the company, what are remaining in the company, what are receivables for the company, what the company should pay to the outside. All these things the liquidator, like an accountant in first place, who will be doing the liquidator's role and liquidating the company assets and liabilities. The court may appoint a liquidator provisionally at any time after the presentation of a winding up petition or before making of a winding up order, and either the official receiver or any other fit person may be so appointed. So at any juncture, when the court feels so, the court can appoint a liquidator. So the liquidator is a person who is attached to the court, who is responsible to the court, and who is answerable to the court. He is a kind of a person in trust who has a fiduciary duty towards the court. However, the official receiver shall, by virtue of his office, become the provisional liquidator. So for the time being, until a liquidator is appointed by the court, the official receiver will operate as the provisional liquidator and shall continue to act as such until he or another person becomes liquidator and is capable of acting as such. The official receiver shall summon separate meetings of the creditors and the contributories of the company, so that the official receiver will get to know the clear picture of the company affairs. For the purpose of determining whether or not an application is to be made to the court for appointing a liquidator, then he will report to the court whether it is important to proceed further in appointing a more qualified liquidator in place. In a case where the liquidator is not appointed by the court, the official receiver shall be the liquidator of the company. Where the official receiver becomes the liquidator of a company, whether provisionally or otherwise, he may where satisfied that the nature of the estate or business of the company or the interest of the creditors or contributories generally require the appointment of special manager of estates or business of the company other than himself. Sometimes the official receiver may even appoint a manager by informing the court, a competent manager who can carry on with the ongoing business until the businesses are brought to a complete end. Because sometimes there may be situations where certain contractual obligations are to be met by the company. So winding up does not mean that the company is left with further liabilities, that there could be a breach of contract. So in that case, to make sure that the company or the third party does not suffer, the manager, competent manager could be appointed so as to take care of a certain business affairs being conducted. Now in Sri Lanka, when these kinds of things happen to where some leading financial institutions in the recent past, there have been situations where competent people were appointed just as to be made a manager until the complete closure is made in the winding up process. Where a person other than the official receiver is appointed liquidator, he shall receive such salary or remuneration by way of percentage or otherwise as the court may direct, and where more than one such persons are appointed liquidators, their remuneration shall be distributed among them in such proportions as the court directs. No act of a liquidator shall be or shall be deemed to be invalid by reason only of any defect in the appointment or qualification of such liquidator. Where a winding up order has been made or where a provisional liquidator has been appointed, the liquidator or the provisional liquidator, as the case may be, shall take into his custody or under his control all the property, whether they are liquid or static or movable or immovable, whatever, and things in action to the company is or appears to be entitled to take on to his control, into his control. So with that, I come to the end of today's lecture, and next day, which would be the last lecture of this particular series, I will be finishing the area of the company dissolution and winding up, and we have 3 more other areas to look into under the Companies Act, which I will be going through and talking about the liquidators, duties of the liquidators, functions and powers of the liquidators and so forth, which are very important for you all as students of accountancy, where when you all become accountants, you will have the opportunity of acting in the role or capacity as a liquidator in these kinds of company matters. Thank you very much for listening. I do hope that you have gathered, like always, the knowledge out of my lecture and the success that you need to prove at the exam. Thank you.